Hi friends from around the world. This is about enforcement, and you are a lawyer from around the world, and this is one of the important cases I will present to you with regard to international jurisdiction. You know what international jurisdiction means. It is in cross-border cases whether the courts of one country are competent to hear the case or not. Now, you know already that a good guess would be the domicile of the defendant, right? And this is also the case here in Europe. With regard to trademarks, for example, we have Article 125, which previously was Article 97. I mention this because in the case I want to present to you afterwards, it is 97 still. So the defendant's domicile is a good guess, and it is true. It is in all the cases, I think, around the world. International jurisdiction is where the defendant has its domicile. That is always a good case. Now, let us come to a hypothetical case. So to say, you are in Malaysia, and you have a defendant, an infringer, so to say, in Nigeria. And let us link this to Europe. We have an infringement in Europe. Now, what does that mean? Well, you can go to Nigeria, right, in order to defend your damages or whatever it is, what you want to have from them, information or whatever. You can go to Nigeria, right? Is that a good alternative? Well, not exactly, right? There is one thing, so you are interested probably in order to know what other international jurisdictions you have. But there are other considerations which not only comprise the international jurisdiction. You should look a bit further, if possible, in order to serve our client better. So it is not about, well, I got now the international jurisdiction, I go for it and I will kill that guy. This is not the right way to serve the interests of your client. So you have to look further. For example, you want to have knowledgeable judges, right? So knowledgeable judges on the EU law, because the infringement has been in the EU, you will not find in Nigeria. I suggest that this is not the case, unless these judges, they are here in my in that course. They know the videos here, but just kidding. This is not the case. So you will not have knowledgeable judges, and you know, without knowledgeable judges, I don't know what kind of outcome you will expect in that country. That is one thing. The other thing is, what about enforcement? So if you are successful in court, and I hope you are, then you will need to enforce the sentence, to execute the judgment, right? So through the law enforcement measures or instruments you have in that country. Now, is that so that you have a good law enforcement in Nigeria? I don't know. If you have a judgment in whatever country, it can be a European country, and you want to enforce it in Nigeria, that is also a headache. Because you have to go through the Ministry of Foreign Affairs in order to put an apostille on it, and then it has been sent through diplomatic channels to that other country, and depending on the agreement between the governments, if there are or not, you may probably or may have a possibility for execution. But this is not really something, so it takes years in order to get to this, and infringers often, they disappear overnight. And everything is for nothing, and there are only expenses on behalf of, on the account of your client, who is not happy about all this. But this might have some thinking of you. Will I go for everything, for example, damages, or will I my goal is to stop infringing and forget about all the rest? Well, I don't want damages because it's too complicated to go through. So my interest, or the interest of your client, is a quick reaction in order to stop infringement. So probably it would be that only. which you would aim for. So this is the overall picture, but let's come back to the international jurisdiction, which is complicated enough in order to give you here the possibility to look closely. This is about Article 125 here on the screen, and let us go a bit through it. What does it say? Well, the standard is that the defendant has the domicile in one of the member states of the EU, and the international jurisdiction is in that member state. Well, we know this, and we have already talked about it. Now, if the defendant has no domicile in one of the member states, but an establishment, so it could be a representative office, a bit more than a warehouse or something, then the international jurisdiction is also in that member state. This is still Article 125.1, right? So if the defendant has nothing in the EU, but the plaintiff has something in the European Union, then it is, the good news, it is in the member states in which the plaintiff has its domicile or an establishment. Article 125.2. Now, if there is no establishment or no domicile in one of the member states of the defendant or the plaintiff, so none of them has anything, then the international jurisdiction lies with the Trademark Court in Alicante, European Trademark Court in Alicante, Spain. Why there? Alicante, Spain? Well, you know, there is EUIP, this is the seat of the EU IPO. And there is still another possibility linked to the place of infringement, which is Article 125.5, which will bring us to the case I want to present you today. So the case is about a UK company who is in the audio equipment and a Spanish company also in the audio equipment, right? And the Spanish company, they had some internet page, and the internet page was in English, and it was accessible to the consumers in the UK, and they offered for sale infringing products. That is more or less what it is about. And the UK company, they sued the Spanish company in the UK court. Now let us quickly go through the possibilities of determining international jurisdiction, as we have seen just a minute before. So let's just repeat this exercise. Article 125.1 has the defendant a domicile in the EU? Yes, in Spain. So it could have been sued in Spain, but it does not give 125.1 international jurisdiction to the UK court, right? Establishment in the UK? No. Is there has the plaintiff its establishment in the UK? Yes, but if the other has, then this is not sufficient in order to establish the international jurisdiction in the UK. What about the seat in Alicante, the EU Trademark Court in Alicante? Well, as the plaintiff and the defendant are in the EU, the Alicante court is not really competent, and therefore we are in 125.5, which says about the acts of offering, advertising and offering of goods or threatening to do so. And the UK courts which were sued, which were occupied with that case, it went to the higher court, which says then, well, I have a doubt about that. Previous EU case law does not exist really with regard to online infringement, so we need to look a bit into this. And they referred the question to the European Court of Justice, the referral, typical, and which was about the question whether a advertising and offer for sale of goods on the internet, which are made accessible to the consumers of the UK, is this sufficient in order to establish the international jurisdiction of the UK courts? So the act of infringement, is that sufficient in order to say, well, there's an act of infringement of the defendant in the UK? Well, it is an important case because it is the first time that it had to be decided on this. So it is previously there was a L'Oreal case, which I may or may not, I will see, discuss in detail, but that was on not online infringement, but on the goods as such. In this case, the goods as such were in Spain, so they were not brought into the UK so far. Now, and this went to the European Court of Justice, and the Attorney General was there. And again, you may want to read the Attorney General's opinion, which has been followed by the European Court of Justice, and it says, well, in reality, if the access has been granted to the targeted consumer in the UK with regard to the commercial content of the advertising, of the offer, of the real offer, then it would be qualified as an act of infringement. So it is not limited. It was a broad interpretation, so to say, of Article 125(5). It could have been a narrow interpretation by saying, well, it must be the server must be located in the UK, or the act of uploading the content to the internet that must have been taken place in the UK, so that association with the UK territory can be established. But no, it was friendly, so to say, for the infringers, not for the trademark owners, in the sense that they opted, so the European Court of Justice opted for a broad interpretation of this Article 125(5). Now, is that now all good? So is that good for the right owner to have that possibility of Article 125(5)? Well, it's good to have that possibility, but it doesn't solve everything. There's a caveat into that. And the caveat is that the 125(5) does not permit to rule in the UK court all the infringements across the European Union. This is a possibility in Article 125(5). So all the infringements which have been, if the defendant is domiciled in Germany, though the German courts are competent for judging all the infringements across 27 member states in the EU. Right, so everything can be ruled out in one sentence, so to say. Article 125(5) only permits that the country, in that case the UK, is competent for ruling on the infringements in the UK. So it's territorially limited. So, by the way, it was UK before Brexit, right? So Brexit does not intervene here. So this is the caveat which you have to take into account. And does that mean that we have the possibility of 27 different rulings on one case, on one infringement within the EU? No, which is always one thing the European Court of Justice worried about. No, they want the only instance to rule about European law. No, it is not. Because the cases in the different countries are isolated cases, are different cases, are not comparable cases with one to the other. So there is not that danger does not exist. So international jurisdiction. I hope you enjoyed this one.